Hello, Miss Prendergast.
Good job.
Good to see you.
Good afternoon.
I always have to get that R in the right spot.
People, they like to
Yes.
drop the R's. It is
Yes.
a common occurrence. It usually surfaces at the end of the name as Prendergast.
So it's good to see you today.
Thank you very much.
Yeah, thank you. You may begin with your opening comments.
Thank you. I feel as though I should be inquiring if you have a frequent flyer program or at least a rewards card that I could take part in. Thank you very much for the privilege of your time today and your service on this commission. It's a weighty task and one that I can tell all of you take very seriously. And I think I said before, as a private practitioner, I enjoy and have enjoyed the fact that I can tell that you all take this job very seriously, because for those of us that are in the private practice, we value the integrity of this system and the Court of Appeals very much. I'd like to take a little bit of time just talking about my upbringing, and then I'd like to talk a little bit about the traits of a Court of Appeals judge that I think are important, and then a bit about the future of this Court of Appeals. Both my parents worked full-time. My mother was a nurse and worked holiday hours and long hours, and my father was an Air Force accountant. And as such, I knew early on that both of them working full-time afforded me things as a child that oftentimes a lot of children in our current juvenile justice system do not have. I was acutely aware that because of their work ethic, I was able to come home as a latchkey child and watch the Partridge Family and the Brady Bunch and memorize all the songs that are in those wonderful shows. I established independence as a child because of that. I actually had the latchkey around my neck and let myself in when I came home from school. And I appreciated that my parents were at work, and because they were there, I knew that I had things that other children did not have. And my parents were so astute to remind me early on that to whom much is given, much is expected. That rang true for me for years, and it continues to be something that I value and that I remind myself of daily. Because I've had the opportunities that I've had, I take very seriously my job, my representation of my clients, and I know that it's my responsibility to give back to the practice of law, to give back to those clients, to give back to my community as a whole. Once I knew that I had talents that included reading, writing. I was strong academically. I discovered throughout college that I enjoyed leadership positions. I enjoyed being on committees. I enjoyed interacting with other students and serving in those roles. It became clear that the practice of law was going to be a good fit for me. I was strong as a writer. I was strong in reading. And probably most importantly now looking back, I care about people. And I found that empathy has served me very well in my continued representation of clients. Before I embarked on this process, almost 8 months ago when you first started the rounds of this, I thought long and hard about what the traits were for an appellate court judge that I thought were important and whether or not I fit within those. I did not want to undertake a process that I didn't think I could do well. I don't do anything small in my life. I give everything 110%. I always have. Quite honestly, I don't know any other way to do it. Maybe that's part of the to whom much is expected, or to whom much is given, much is expected. It's been a constant through my life. I'm not always perfect at everything. I would have loved to have been a star basketball player, and with 6 feet, one would have thought that might have worked out. But I ended up not playing Division I basketball, and that's just okay. That didn't mean that I didn't give it 110% when I was in high school. As such, I examined those traits, and I looked into myself, and I looked into the other judges that were on the bench, and I asked myself what were the important qualities that someone needs to have in that role. And as I thought more about it, 2 big areas developed. The first is what I would call tangible traits, the things that all of you can probably see from the application itself, from the person. One of them is clearly work ethic. You cannot take on a role as a Court of Appeals judge without having a strong work ethic. It is a bench that is busy. They have a lot of work to get through efficiently and diligently. and they're expected to do it at the continued pace and process that has been going on for a number of years now. For me, working on Sundays is the norm. It's what I know, and I don't leave work until my desk is clean. It's been something that I've done from day one, and it's not changed. I don't go home at 5. I stay until everything is caught up and needs to be done. As such, the work ethic and the caseload for the Court of Appeals does not intimidate me. It's the norm for me, and it's an expectation for me. The second tangible trait that I think you might be able to see from someone's application would be writing skills. There's no question that the Court of Appeals is producing documents, and they have to remember the audience that they're writing for. There are two big members in that audience: the lawyers, who have to read the opinions and provide the best advice to their clients, but more importantly, the litigants that have to understand the opinion. Those folks have been part of a process, and they need to be able to read that opinion and understand it without being mystified by the legalese or the words that are contained therein. That's an important perspective for a Court of Appeals judge to always remember when they're writing. I enjoy writing. Oftentimes, as private practitioners, we don't have the same contemplative time and ability we would like to be able to write as completely and thoroughly, because unfortunately the practice of law can be quite busy. I yearn for an opportunity on the Court of Appeals to be able to be contemplative and spend more time writing. But it is a tangible trait that I'm sure you all are considering. The third trait that occurred to me in contemplating the Court of Appeals judges and what they need to have is an intellectual curiosity and diversity of experience. When I look back at my career and then I look at what the Court of Appeals is making decisions upon, the vast majority of what they are ruling on, and I've used this phrase before, is my wheelhouse. I have become, I'd like to think, an expert in family law. I consider myself a go-to person in the Cedar Valley in that area, and when I say family law, I'm including juvenile justice, child in need of assistance proceedings, termination proceedings, both private and public, juvenile delinquencies, dissolution matters, custody cases, and the like. I also have a significant experience in criminal law. I've enjoyed my time in criminal law, most recently had a jury trial in January of 17, and feel as though I know it quite well. So that intellectual capacity and curiosity is something that is important for a Court of Appeals judge. You have to like what you're studying and reading. You have to feel connected to it. All of those things are helpful in making sure that those litigants and the people of the state of Iowa are getting the most thorough and competent review of their case. Then I thought about the intangibles, the things that you might not be able to see from the pieces of paper, actually the electronic version that's in front of you. You probably don't get the pieces of paper anymore, but the things that that might not jump out at the page, that you only pick up on from either meeting me or listening to the comments that you might get from my clients or my colleagues. One of the intangibles that I think is so important is a passion for the system. You've got to care about the people that are participating in this system every day, because they are behind that paper. They are the ones that are counting on the Court of Appeals judge to spend the time to thoroughly review it, give a diligent review, and render the best opinion possible. I'm sure it's been mentioned multiple times, but another intangible is obviously a collaborative ability. This is a panel of 9 and many more once you add on the senior judges. An individual has to be able to work collaboratively and collegially with all of the other judges that are on that bench. I look back at my history and my participation in multiple boards, on school boards, on committees, and I enjoy working with people. I enjoy giving back to my legal community. I enjoy the interaction with people. I'd like to think I have strong communication skills. I'm a certified collaborative mediator. I'm a certified mediator. Those skills have served me very well in handling my clients, in dealing with other lawyers, in trying to reach resolutions. Yes, I've tried cases. The vast majority of cases, as many of you know, get settled. They get settled because of the mediative work and the collaborative work that has to happen in order for that to be accomplished. The next intangible trait that dawned on me that I thought was very important was humility. It's so important for a judge on the Court of Appeals to remember that you are one of 9. And after you all make a decision as to who's best qualified to serve in these roles, and once a governor makes an appointment as to who that individual will be, it becomes much less about me and much more about the people that are expecting the most competent and thorough review. The ego needs to be checked at the door, because those 9 individuals should continue to focus on the litigants that expect the best of our justice system at all times. I want to wrap up with a couple footnotes to my thesis on a Court of Appeals judge and how a Court of Appeals judge best serves the people of the state of Iowa. Previously in my application, I had talked about a juvenile case of mine where I served as a guardian ad litem for a young lady. I've represented her for a little bit shy of 10 years now. On Saturday, she got married. She's 23 years old. She is graduating from college. She is finishing up her studies in elementary education. And as she walked down the aisle on Saturday, I couldn't help but feel energized and passionate about our system and how much good it can do when it works the way it needs to work. And so I bring her up because I know I had mentioned her before in a number of my applications, and I was so proud of her on Saturday and so proud of our system for serving her as well as it did. And I bring that up, yes, because I'm proud of the work I did for her, but mostly because I think it's really important for a Court of Appeals judge to still have passion for our system. Certainly there's days where lawyers are cynical. It happens. But on Saturday, I realized I'm not cynical. I believe in our system. I believe in the beauty of the things it can do. I believe in its ability to be a dispute resolution solver and problem solver. A Court of Appeals judge has to continue to be the guardian and gatekeeper of this fabulous system that we have. I am absolutely yearning for that journey and that role to continue in that. Finally, one last footnote, and then I'd love questions. All of these traits and skills that I think I have in terms of analytics and analysis and decision-making have not assisted in the weighty decision in my household as to which Iowa University my son will attend next fall. So I will gladly take any input and counsel from any of you all as to where he should attend, because at this point, all 3 of the Iowa schools are in the running, and he can't decide, and I'm having a hard time telling him where to go as well, since they all seem to be quite qualified to serve in that. With that, I would love to entertain your questions.
Thank you. And we'll begin with Mr. Hoytig.
Okay, well, first I will plug Central College in Pella, Iowa, which recently redid its tuition structure.
Central College.
I was going to ask you who your favorite Brady child was, based on your story of your upbringing, but one of the unique things I think judges get to do, and I had the experience to work with a judge, is to be a clerk, and you're mentoring new lawyers who will, and frankly, really good law students who came through, and they get to move out and hopefully change the legal system and be members of it. Have you had experience in mentoring associates or mentoring young people in your community?
Yes. We've had 3 associates pass through our firm, all in different age groups. And on the positive side of the mentoring, I found that it helped me think through clearly what were the most important things I wanted them to be able to do in terms of the day-to-day practice of law, the little mantras that my mentors gave me, such as always do something, always return that phone call within 24 hours, always return those emails. They were beautiful reminders of navigating that establishment. The difficulty, I would say, about it is that not everybody works the same. Mm-hmm. Not everyone practices law the same way I do, and I can't expect everyone to practice law the same way I do. I can give suggestions and I can give comments, but they have to find their own path. They have to find what works for them, which, if you were to akin it to the Court of Appeals, I'm sure happens on a daily basis. Some of them may be voracious emailers, and they communicate a lot via email. Other folks may be more in person. I think it takes some navigating to figure out which way individuals operate best, and making sure that you utilize what you learn from that so that you're managing that relationship and you're feeding their skills that work best with your communication skills.
Thank you.
Ms. Valentine?
Thank you. I'm curious if you have any suggestions or changes that you think the Court of Appeals should enlist in if you think there are any changes that need to be made, and what those changes would be.
EDMS has been a wonderful addition to our justice system in terms of its speed and efficiency. What has happened as a result of that is that the communication and the FaceTime with the judiciary has significantly reduced. As such, I would like to see the Court of Appeals be out in the public domain a little bit more than what they currently are. I would enjoy to see them travel for oral argument just like I see the Supreme Court doing it. I think the more that the people of the state of Iowa can see firsthand what their Court of Appeals does and how the system works, the more they value it and the more they understand its need and import. That would be one thing that I would like to see. Internal processes, obviously I'm not familiar with a lot of those, but I know Judge Bauer has been here for a long time, and I would value his judgment and leadership in that regard without question.
Thank you.
Mr. Berger?
No questions.
Ms. O'Brien?
No questions, thank you.
Mr. Sukup?
No questions.
Ms. Conover?
One of the questions that comes up for the commission when we're filling these positions is, do we value the experience of somebody coming out of private practice, and how do we weigh that as compared to the folks that already have judicial experience in the form of district court or district associate court positions? How would you counsel us to weigh those different backgrounds as we're considering very qualified applicants?
You are, and that question has come up a lot. There's no question that prior experience as a judge gives you the opportunity to write, gives you the opportunity to make fact findings, gives you the opportunity to apply the law to the facts and render your decision. I would propose that a private practitioner does much of the same. It's probably not, it might be a bit of a stretch for me to say that I judge every day, but there are times where I do feel like I judge every day. I intake a client, I meet them, I absorb all of their facts, and then I start down the next path of determining what the facts on the other side are going to be, because the best way for me to prepare my case is to find out what the other side is. And then I'm giving my client the best legal advice based upon both sets of those facts. So while I may not be judging in the sense of the black robe and issuing the findings of fact, I am judging within my own processes, because I have to tell my clients whether or not this trial is worth having, or this one you shouldn't have, or you should agree to this, or you shouldn't agree to that. All of those things go into that decision making. I also think that the perspective of a private practitioner is important for the Court of Appeals, having individuals up there who know what that process is like at the district court level, know firsthand what representing an individual charged with a crime is like, knows firsthand what prosecuting that crime is like. All of that knowledge and perspective is important to bring to that collaborative process in the decision making. So I don't think either one position is better than the other. I think they both provide a valid concept and trait for this commission to weigh, and keeping a balance of those perspectives on the Court of Appeals is important.
Thank you.
Well, thank you for being here today. We are out of time, and I apologize for that. It goes very quickly, doesn't it?
It does. 20
Yeah.
minutes turns into a minute.
It does.
Yeah.
It does. Well, thank you for being here.
Thank you.
And we certainly wish you well.
Thank you very much for your service.
Thank you.